Yes, Mr. Sullivan.
Thank you, my lord. Just before the short adjournment, I had been asking the court to look at Hip Foong Hong, and it's my submission that that case is concerned solely with the question of materiality. The question of whether the reasonable diligence test should be applied is simply not addressed at all, and so the case cannot safely be read as an authority in which the court finds that that requirement does not apply. And my construction is the construction that Lord Justice Patten adopted below. It's the construction Mr. Justice Burton adopted in Chodiev and Mr. Justice Langley in Sphere Drake. And I pause there to say that in that context, it's not surprising that in the Owens Bank cases, this case wasn't referred to, because it just doesn't address the question. It doesn't undermine the reasoning in those cases. And the same point can be made as to the Jonesco case, which is the other authority that my learned friends rely on in this regard. That case can be found at page 1201 of the electronic bundle, bundle 2 in hard copy, behind tab 19. My learned friend showed the court page 1203 electronic 357 hard copy from the speech of Lord Buckmaster. Beginning about just above halfway down the page, he addresses first, on the hearing before the Court of Appeal, the first part of the case, which concerned evidence that did not involve allegations of fraud. And then he goes on, it is the charge of fraud that is the sole reason supporting the judgment now under appeal. And then he goes on to address the procedure. He says, the procedure taken was irregular. It's long been the settled practice of the court that the proper method of impeaching a completed judgment on the ground of fraud is by action in which, as in any other action based on fraud, the particulars of fraud must be exactly given and the allegation established by the strict proof such a charge requires. That, in my submission, is not a judge deciding when an allegation of fraud may be considered by the court. That is a judge saying that if you apply to set aside a judgment on the ground of fraud, you have to prove it. And that, we say, is an entirely separate question. Over the page, another section that my learned friends rely on, page 358, hard copy, 1204, electronic, towards the bottom of the page, the fraud charge related to the claim for the price of the 2 horses alleged to have been sold to the appellant. Were such fraud properly established, I agree with the Court of Appeal in holding that the whole judgment would thereby have been vitiated. Pausing there, that is uncontroversial. If the fraud is proved, the consequence is the judgment goes and there'll be a retrial. But the question before this court is not what should the effect be of a finding of fraud. It is in what circumstances should we permit the allegation to be pursued, even if it could and should have been raised earlier. And then finally, and that this goes on in the same paragraph and over the page, assuming then that the difficulty of procedure is overcome, was such fraud specified and proved here? And that's the ratio of the case. Because what, in addition to the procedure points, the Lord Buckmaster then goes through the evidence and he says, there's nothing in it. and so the claim fails. It's of note, we say, that in almost all of these cases that the appellants rely upon, the claim to set aside the judgment for fraud fails. In almost every case, the person alleged to have been a fraudster is allowed to retain their judgment. And that's a point that I'll return to.
Your essential point is that there was no occasion in any of these cases for the court to advert to the question of whether reasonable diligence was required.
In none of the cases that the appellants rely on.
I think what Mr. Wardle might say, by way of riposte, is that it's surprising, to put it at its lowest, that there wasn't any reference at all to reasonable diligence, if it occupies such a prominent position as you claim it to do, in the whole question of whether the opportunity should be afforded to the person who claims to be the victim of the fraud to seek to reopen the matter, or have the judgment set aside, rather.
Well, in my submission, it depends on the circumstances. If the defendant to the new claim has a good argument that the evidence could and should have been discovered at the original trial, then one might expect the point to be pursued. But there's no suggestion in this case that was what happened.
Yes, well.
And so, drawing then all of the authorities together, we say that it is a clear, established principle of English law that the reasonable diligence requirement applies in an action to set aside a judgment for fraud. And it's long been understood to be the case. And we cite in our written case the Law Quarterly Review article my learned friend referred to of Mr. Gordon that was written in 1961 and sets out the rule as being entirely uncontroversial. Whilst, of course, we accept that the court can overrule Hunter and can overrule Owens Bank and Bracco by reason of the practice statement if it wishes, we say first that it should be circumspect in doing so. How the court will be well familiar with the principles to be applied. It's not enough that your lordships and your ladyship considers that they would have decided the cases differently. It has to be something more than that. But in any event, we say that as a matter of policy and principle, the reasonable diligence requirement in this context is justified. And so that brings me to the second section of my submissions, which is policy and principle. We say that the starting point is that there are three general principles of English law which are not in issue today, but which inform the court's decision as to the validity of the reasonable diligence requirement. Principle number one, parties are expected to exercise reasonable diligence in advancing their whole case when they are involved in litigation and arbitration. We say that is encompassed in the well-known rule in Henderson and Henderson. Principle number two, ordinarily, save for the possible rights to appeal, judgments and arbitration awards are final and cannot be challenged or attacked by fresh action. And this, we say, is encapsulated in the principle of res judicata, cause of action estoppel and issue estoppel. And the third principle is there is an exception to res judicata if, in respect of the issue, there is new evidence which could not, with reasonable diligence, have been deployed at the original trial. And we say that that principle is consistent with Principle 1. Now, we say that without more, those principles taken together would support the application of the reasonable diligence requirement when a party seeks to set aside an earlier judgment. And so the appellants need to point to something, some special factor to take us away from those general principles. And the special factor that they point to is what they say is the particular status of an allegation of fraud. They say, at paragraph 4 of their written case, that the general approach of the law is that fraud claims are not defeated by a lack of diligence on the part of the victim. Now, there is a fundamental difference between the parties as to the premise on which this case is being argued. The appellant's arguments presuppose that the defendant in the fresh action is a fraudster. And they argue from this assumption. So we can see in paragraph 4 of their written case, the policy against relitigation does not trump the principle of preventing fraud by preferring a proven fraudster over a careless victim. And they then go on to cite authority as to the strict approach the courts take to proven fraudsters. We say that is the wrong question. We aren't today concerned with what the consequences should be of a finding of fraud. We accept that the consequences are and should be serious. But my clients are not proven fraudsters. On the contrary, they vehemently deny the allegations made against them. Just as we can see in almost every case, there is an issue as to the allegations made.
How is that to be relevant in a case where the point is being decided as a preliminary issue? We have to proceed on the basis that your submission is that this should be effectively struck out, even on the footing that your clients were fraudsters.
We say that it's relevant because it informs the policy analysis. It's one thing to say, oh, look, we're dealing with cases here where on the one hand you've got a fraudster and on the other a negligent victim. But that isn't the right question. What you have is a case where you have a victim who is alleging fraud and someone who may be a fraudster, but they may be completely innocent.
But your case involves denying the alleged victims of fraud the opportunity to establish it.
Well, it doesn't, in my respectful submission. Because of the procedure that would be adopted, it would be within the choice of the victim. And I touched on this, I think, when we were looking at Boswell and Coates, that the procedure would be there is a claim by the losing party to the original litigation seeking to set the judgment aside. And at that stage, the winning party in the original action, the defendant in the second action, could, if they chose, apply to strike the action out on the ground that it was an abusive process. But that's up to them. If they don't apply to strike the claim out, then there'll be a trial which will deal with all of the issues.
Yes, but that's completely removed from the circumstances of this case, isn't it? And you have chosen to have this tried as a preliminary issue, and the consequences of your success is that the appellant doesn't get the opportunity to produce the evidence which she says will establish fraud on the part of your clients.
That's got to be because the fraud's got to be assumed, hypothetically, for the purpose of deciding the issue of principle.
I entirely agree with that, my lordships, and it may be that I simply wasn't making myself clear. Or the point that I was trying to make is that when the court is asking itself, should there be a reasonable diligence requirement, it should bear in mind, in my submission, that if the requirement is removed, it will be exposing innocent defendants to the cost and expense and trouble of a new trial where inevitably, in most cases, one would think there'll be disclosure, witness statements. It could be a fairly big job, if I could put it that way.
Yes, but if they are innocent, they should recover the costs, shouldn't they?
Well, in my submission, in any litigation, there are always losses. So there are, even if an order for indemnity costs is made, there'll be irrecoverable costs. But there'll also be other detriments for which the law affords no remedy.
The fact is that if you have a judgment that goes against you and you want to postpone the evil moment of its implementation, then you would say you could create a colourable case in order to seek a set-aside.
Lord, yes, and we'll see that that's exactly the point raised by the Court of Appeal of New Zealand when it decided that it preferred the English approach to this question to the Australian approach.
But isn't the claimant protected, the winner in the court below, protected by the fact that there has to be convincing proof of a fraud? And if it's clear that that could never be shown, then you would apply to strike out on the grounds of an abuse of the process. There was no chance of this, no prospect of success at trial if the evidence is not there.
I accept that in principle that ought to be possible, but practically speaking, one can see that that is likely to be a fairly difficult course of action, because that is an application for strikeout resting on what the claimant would inevitably say are fact-sensitive issues, and the courts are notoriously resistant to striking out claims.
In effect, it would have to be established that there was no reasonable prospect of success for the claim. And that's a difficult argument to advance before the evidence is in.
Yes, my lord, and so in most cases one would expect a judge to say, if the very question that the strikeout is predicated on is, was there fraud, we ought to let this go to trial.
Well, one can see that there are competing factors in play here, which will assume lesser or greater importance depending on the particular circumstances of the case. Is that not an argument in favour of the exercise of a discretion which reflects the circumstances of the case?
Well, we would say no. We would say that the current test, which is set as a requirement rather than as a discretion, properly balances the issues, but importantly is consistent with the way that this issue is approached across the rest of English law. When I say the issue there, what I mean is the circumstances in which someone alleging fraud who has failed to exercise reasonable diligence in advancing that allegation is permitted to continue with the claim.
Yes.
And so I say that the court should bear in mind the potential innocence of the defendant and ask, on the facts of this case, should my clients have to defend themselves from yet further litigation in these circumstances? Should parties, losing parties to litigation, be permitted to make allegations of perjury, for example, which are easily enough made, and often a tempting allegation, one would think, to be made by a losing party, on the basis of material that they could have deployed first time around? My clients in the original trial in these proceedings have already been put to costs of over £800,000, together with the loss of considerable time and considerable stress. Should they and other innocent parties, and I accept that that won't be determined at this stage, but should they in principle and other innocent parties who are wrongly accused of fraud be put to the cost and burden of a further fraud trial because the person making the allegation failed to exercise reasonable diligence when they had their first use of the court's resources? And as we say in our written case, we acknowledge that there are competing policy interests at play in addressing this question. We outline the policy considerations we have identified in paragraph 29 of our written case. Of course, the very availability of this action at all comprises a recognition of the interest the court has accorded to preventing fraud and preventing fraudsters from benefiting from their fraud. Ordinarily, one can't bring a fresh action to set aside a judgment. We say, and I think this is a point that maybe I've already made, that the existing approach strikes a fair balance and is consistent with the general approach of the law.
Yes, I think you have made that point.
I think I have. And we say that it is wrong for the appellants to suggest that the general approach of the law is that parties alleging fraud are not defeated by a lack of exercise of reasonable diligence. And we give 5 examples of this in our written case. The first example is arbitration. In the 5th bundle of authorities, behind tab 53, page 2203 of the electronic bundle, we have the part of the 1996 Arbitration Act. And at page 2203, electronic 1252 hard copy, there's section 68, which provides a party with a right to apply to the court to challenge an arbitration award on the ground of serious irregularity. And one of the species of serious irregularity identified, subsection 2G, is that the award was obtained by fraud or in a way which was contrary to public policy. So that, in the context of an arbitration award, is effectively, we say, a replica of an action to set aside a judgment for fraud. But the circumstances in which that action can be pursued are limited by section 73 of the Arbitration Act, at page 2206, electronic 1255 hard copy. If a party to arbitral proceedings takes part or continues to take part in the proceedings without making, either forthwith or within such time as is allowed by the arbitration agreements or the tribunal, or any provision of this part, any objection, and then subsection D, that there has been any irregularity affecting the tribunal, he may not raise that objection later before the tribunal or the court unless he shows that at the time he took part or continued to take part in the proceedings, he did not know and could not with reasonable diligence have discovered the grounds for the objection. We say that that is a statutory implementation of the reasonable diligence test in the context of attempts to set aside arbitration awards for fraud as against judgments for fraud. And it's been treated as such by the courts, and the 2 examples we give in our written case are the Mariana, which for the court's note is page 2086 electronic, bundle 4, tab 48 hard copy, and the case of Nestor Maritime, which is page 1420, electronic, bundle 2, tab 28, hard copy. Now, we accept that there are some differences between arbitrations and litigation, some differences between judgments and arbitration awards. But we say that this is the closest analogous situation in English law to a claim to set aside a judgment for fraud. And in that context, Parliament has struck a policy balance and decided to apply the reasonable diligence requirement. And we say that the differences between arbitration and litigation are not such as to provide a good reason for the court today to remove the reasonable diligence requirement in the context of judgments, and thereby create a difference of approach between setting aside judgments and setting aside arbitration awards for fraud. The second example we give is limitation. We point to section 32 of the Limitation Act, which can be found at page 2208 of the electronic bundle behind bundle 5, tab 54 of the hard copy bundle. It may be well known to the court. An action for which there is otherwise a limitation period set in the 1980 Act, which is based on the fraud of the defendant, or where any fact relevant to the cause of action has been deliberately concealed by the defendant, the limitation period shall not start to run until the earlier of the date on which the claimant discovered the fraud or concealment, or could, with reasonable diligence, have discovered the fraud or concealment. So, as against a party who might seek to allege fraud, limitation starts to run even if that potential claimant has not actually discovered the fraud or concealment, simply if he ought with reasonable diligence to have discovered it. And so it follows that a failure to exercise reasonable diligence may cause a claimant with an otherwise good fraud claim to lose the right to have that claim determined on the merits. We point out that Parliament could have adopted a test of actual knowledge only, but it chose not to. And we say a hypothetical example highlights the importance of maintaining consistency in this respect between the application of the reasonable diligence criterion in limitation and the application of the requirement when considering the test for setting aside a judgment for fraud. Suppose that Party D forges a document and on the 1st of January 2000 obtains a pecuniary advantage from Party C on the basis of that document. Suppose too that Party C could, with reasonable diligence, have discovered and evidenced the fraud by the 1st of January 2001 in a year. If Party C wished to bring a claim in that context, at the very latest, they would need to issue it by the 1st of January 2007. And if, due to a lack of reasonable diligence, they failed to do so, they would lose the right to have the allegation of forgery determined by the court. The court would bar the claim because of the lack of the exercise of reasonable diligence. Suppose then that instead, well, in fact, within the example, Party C, in fact, issues a claim seeking recovery of the monies paid over in 2005, but again, through a lack of reasonable diligence, he fails to advance or evidence any case in forgery, and he loses the trial, which is heard in 2007. Then, on the 1st of January 2008, he twigs, and he spots the point, spots the fraud, gets the evidence. In that situation, if he had never sued at all, he wouldn't be permitted to advance his allegation of forgery in court because he'd be time barred. But if the appellants are right, and if the reasonable diligence test in setting aside a judgment for fraud is removed, he would be able, in that situation, to advance his allegation of forgery at any time. There'd be no limitation period even. We say it can't be right as a matter of principle that party C in that hypothetical example is in a better position in terms of his access to the court, having already had one bite of the cherry, than if he hadn't used the court's resources at all.
What is the limitation period for setting aside a judgment?
We say
Prescribed
there isn't one. There isn't one under the...
Well, then this section doesn't apply. You've got to find an action for which a period of limitation is prescribed by the 1980 Act.
I think you're using it by way of analogy, really, aren't you?
So the point that I was seeking...
Drawing up the anomaly that you say would exist,
Forgive me.
rather than this having any direct effect on the situation.
My Lord, yes.
Would this be another reason perhaps to invoke a discretion and to say that in circumstances such as those you describe, it would not be appropriate to permit a party to try and open up a judgment again on the grounds of fraud?
I accept that that would be one approach that the court would take. What I would say is that under the Limitation Act, there is no discretion to rule. And so the clearest way of maintaining consistency in this regard would be to maintain the requirement rather than to impose a discretion. The next example that we give is the modern approach taken by the courts to amendments to statements of case, and in particular, late amendments. And we say that the approach is strict. This was set out by Mrs. Justice Carr, as she then was, in the Qua and Goldman Sachs case, which can be found in the third bundle of authorities behind tab 36 and at page 1603 of the electronic bundle. The tests, perhaps more accurately, are set out at page 1603 of the bundle, 706 of the hard copy bundle. And the relevant part for our purposes is at paragraph 38F. When a party is seeking to, perhaps I'll simply read it. It's incumbent on a party seeking the indulgence of the court to be allowed to raise a late claim to provide a good explanation for the delay. And that comes from the Court of Appeal decision in Swain Mason, which we've cited in our written case. Now, we say that ordinarily that requirement is similar to a reasonable diligence test, because if the reason the point wasn't pleaded earlier is just we failed to exercise reasonable diligence, then it's unlikely that that will be considered to be a good explanation for the delay.
It is surely that the litigant is asking for an indulgence, whereas the right to bring an action to set aside a judgment for fraud is a substantive cause of action, and it's not a matter of indulgence.
Well, I accept that, my lord. The point that we seek to draw from this is this test is a test of general application. Fraud claims aren't carved out from this test. And it meets the point that the appellants make, which is ordinarily, they say ordinarily, the approach of English law is, if you're alleging fraud, you aren't defeated by a lack of reasonable diligence. And we say this is an example of where you may be, because if you have a claim, whether it's a fraud claim to begin with, or if it's a non-fraud claim but you seek to amend to add fraud, if you raise the point too late and you haven't got a good explanation, then the court may decide that you can't pursue that allegation. And we also say that the fact of this test, again, gives rise to a potential odd inconsistency in the law, again by reference to a hypothetical example, this time based on more closely on the facts of the present case. If we suppose that Miss Takhar in fact discovered the forgery and got her evidence of forgery together 2 weeks before the trial, I should say that there is a dispute as to when Miss Takhar actually knew. We say that she knew long before the trial. But ignoring that for the time being, suppose she got it together 2 weeks before the trial. It must be right, we say, that in that situation, the proper thing for her to do is to apply for permission to amend her case and not just sit on the allegation and wait and think, I'll just have another go later. But if she made that application to amend, then, in accordance with the Goldman Sachs case, the court would ask, have you got a good explanation for the delay? And if her explanation is, I just didn't take enough care, we say that it's likely that her application to amend would be refused. In that situation, the court would have found that Miss Takhar was not entitled to pursue her allegation of forgery because she'd failed to exercise reasonable diligence. Now, if Ms. Takhar's case in this appeal is right, and the reasonable diligence requirement for setting aside a judgment for fraud is removed, she would be in a better position if she discovered the forgery 2 weeks after the trial than if she discovered it 2 weeks before the trial. She would be in a better position if she discovered it 2 weeks before the trial, but she just sat on her hands and didn't apply to amend. We say that there is no good reason for that difference of approach. The fourth example we give on this point is the test for fresh evidence on appeal, the Ladd-Marshall guidelines. Now, we've seen from a lot of friends' submissions that this includes a reasonable diligence requirement for the appeal court is to permit new evidence. And we say the justification for the guideline in those cases applies in a claim to set aside a judgment for fraud, just as Lord Justice Patten found. Now, on this point, the appellants make two criticisms of that rationale. The first is they point to the historical differences between an original action and a bill of review. Well, we've already looked at those. We say that there was a conscious decision to amalgamate the two principles in Boswell and Coates. But in any event, we say that historical distinction doesn't illuminate any reason of principle to justify a difference of approach in the Ladd-Marshall guidelines as against a claim to set aside a judgment for fraud. And then the other point that the appellants make is, well, in fact, of course, the Ladd-Marshall guidelines are just that. They're guidelines. They're not strict rules. And if you look at the cases where there is an allegation of fraud involved, the guidelines are relaxed. Well, we don't accept the appellant's reading of those cases. We address this in paragraphs 59 to 66 of our written case, and I don't propose to go through them orally. The short point is that in each of the cases that the appellant relies on in support of that proposition, the court, in fact, applied the reasonable diligence requirement. They haven't been able to show the court any case in which the requirement wasn't applied because the new evidence in question concerned fraud. The fifth matter, or example rather, that we rely upon is the general approach the courts now take to the control of litigation. We say since the Jackson reforms, there's been a change in the relationship between justice and procedure. And to that effect, we rely on the decision of the Court of Appeal in Mitchell and News Group, which is handed down as a practice direction. It's page 1390, electronic, hard copy, bundle 2, tab 26. In giving the judgment of the court, Lord Dyson, at page 1401, electronic 536, hard copy, referred to his own speech in one of the implementation lectures on the Jackson reforms. And this can be found at paragraph 38 of the court's judgment. Within paragraph 38, at paragraph 26 of the speech, we see the revisions to the overriding objective and to Rule 3.9. That's the provision for relief from sanctions. And particularly the fact that Rule 3.9 now expressly refers back to the revised overriding objective are intended to make clear that the relationship between justice and procedure has changed. And then lower down by H. It's changed because doing justice is not something distinct from and superior to the overriding objective. Doing justice in each set of proceedings is to ensure that proceedings are dealt with justly and at proportionate cost. Justice in the individual case is now only achievable through the proper application of the CPR consistently with the overriding objective. The tougher, more robust approach to rule compliance and relief from sanctions is intended to ensure that justice can be done in the majority of cases. This requires an acknowledgement that the achievement of justice means something different now. Parties can no longer expect indulgence if they fail to comply with their procedural obligations. Those obligations not only serve the purpose of ensuring that they conduct the litigation proportionately in order to ensure their own costs are kept within proportionate bounds, but more importantly, they serve the wider public interest of ensuring that other litigants can obtain justice efficiently and proportionately, and that the court enables them to do so. We endorse this approach. And so, from this, we say there is a greater emphasis than ever on the principle that litigants must exercise reasonable diligence in conducting their litigation, as there is a recognition that there is an ever greater burden on the court's resources, and doing justice in the broadest sense involves considering the impact of a failure by a party to exercise reasonable diligence on other litigants in other cases. And there's no carve out for this principle either in fraud claims. Judges take a robust approach to rule compliance and to ensuring that parties act reasonably diligently when the judge is making case management decisions. And so again, if a party, even with a fraud claim, fails to conduct their case with reasonable care, the consequence of their failure may be that they lose the case, or maybe that it's harder for them to win. That is a consequence of the approach that the courts have decided to adopt.
And I wonder how useful this particular analogy is. I mean, it harks back to a point that we were discussing a few minutes ago. The difference between most of these jurisdictions, and the one we're presently concerned with, is that what you're dealing with now is essentially a procedural principle, whereas the cause of action, the litigation that the claimant wishes to bring is litigation in support of a substantive cause of action. I would have thought on the face of it that there is a world of difference between due diligence as a procedural obligation of litigants and due diligence as an element of a substantive cause of action.
Well, my lord, again, this goes to what appears to be the central policy argument the appellants rely on in support of their case. They say that there is a general principle across English law that if you've got, on the one hand, a potential fraudster, and on the other, party alleging fraud, the party alleging fraud that is never allowed to lose their case because they fail to exercise reasonable diligence. And we say, that's not right.
Well, that may be putting it too far. I'm not actually sure that you correctly represented their position, but let's suppose that that is what they're submitting. The fact that it's too wide may not be enough for your purposes, if there is a difference, a distinction along the lines that I've mentioned.
I accept.
I mean, there may be one rule for procedural purposes, and another when one is working out what the probanda of this particular cause of action are.
Accept that is possible, but if one is prepared to accept the proposition that it is fair, in general, to expect even a party alleging fraud to exercise reasonable diligence in some sense, and I accept that the precise meaning of reasonable diligence is context specific, then that very recognition in my submission is a factor in favour of my client's case in this appeal. And indeed, we say that the facts of the present case are an illustration of this point. Now, I've said there is an issue about actual knowledge in this case, which isn't directly before the court.
Just repeat that, please.
There is an issue about actual knowledge, and that's not the issue before the court. There was a dispute between the parties on that point. We say, we're not, of course, not asking the court to decide this, that it's clear that this point about forgery was well in Ms. Takhar's mind all along. And we know that because after the trial in these proceedings, Ms. Takhar was sued by her solicitors for fees, and she counterclaimed against them on the basis that they could and should have advanced the forgery allegation and adduced evidence of fraud, including handwriting evidence, at the trial. And we have her defence and counterclaim in those proceedings in the bundle before the court. I won't take your lordships to it, but peppered through her own pleading, she makes it clear that the issue of whether or not to deploy a forgery allegation, whether or not to adduce handwriting evidence, was being discussed by her legal team all along, from 2008 through 2009. And in the event, she applied to His Honour Judge Pearl, QC, the trial judge, for permission to rely on handwriting evidence.
Well, according to the statement of facts and issues, she sought permission to obtain a handwriting expert. Is that correct?
The permission under Part 35 would always be to rely. A party doesn't need permission to obtain expert evidence.
Did she turn up in support of her application with a draft expert's report?
She didn't.
That's the point, isn't it? She didn't actually get one.
She didn't get one, and as
She
she
wanted
says...
to know whether there was any point in her getting one. She wanted to know whether she'd be allowed to rely on it.
Well, in her pleading, she says this: permission was not given by His Honour Judge Parle QC for expert evidence, principally because the application had been made late and because there was already a concern about the sufficiency of the time estimate for trial, and the court was not convinced that the evidence would assist.
Anyway, this is the other side of the coin to the question whether one assumes, for this purpose, your client to have been guilty of fraud. This is a preliminary issue, and the question is whether want of due diligence would be relevant, not whether it's present.
I accept that, my lord. I raise this as an illustration of the point that we would say His Honour Judge Parle QC took a robust case management decision in this case, which depended in part, the very case management decision about whether to allow permission for expert handwriting evidence depended in part on the fact that she hadn't made the application sooner, on the fact that she hadn't exercised reasonable diligence in pursuing this allegation. And we would say, and I accept my lord's point, that there is a difference between case management procedural decisions and a substantive right, but the effect of removing the reasonable diligence requirement in a claim to set aside a judgment for fraud, at least in part, allows her to circumvent that robust case management decision. And we say that that would be regrettable. Now, the other points that the appellant makes as to policy effectively boil down to 2 points. They say there's a policy interest in ensuring that fraudsters don't profit from their fraud, and there's a policy interest in protecting the court from attacks on its processes. To that we say, well, any control over the circumstances in which allegations of fraud can be brought before the court may necessarily have the effect of enabling a fraudster to escape civil liability for his fraud. But as we have sought to show, the courts and Parliament have nonetheless imposed such controls, and generally the mechanism by which they have imposed those controls is by imposing a requirement that the party alleging fraud exercises reasonable care in pursuing their allegation. And we say that the imposition of a reasonable diligence requirement in claims to set aside a judgment for fraud is merely an instance of that general approach, a reflection of the policy balance which is struck elsewhere in the law, both by the courts and by Parliament. Moreover, we point out that the imposition of a reasonable diligence requirement is not a demanding test. All it requires is reasonable care, and that itself is a flexible concept which depends on the circumstances of the case. And as Lady Justice Butler-Sloss identified in the Hamilton and Brodie Britton case, which we refer to in our written case, and for the court's note, that's Bundle 1, tab 13, page 1087 of the electronic bundle. In addition, even in a case involving an actual fraudster rather than an innocent party, the imposition of the reasonable diligence requirement, which is failed, does not necessarily mean that the fraudster will get away with his fraud, or that the state is unable to protect the integrity of the court process. Indeed, when one is considering these particular policy interests, we would say that they're in substance closer to being state or public interests rather than specifically the private law interests of the losing party to the original litigation. And that being so, we say that they are more appropriately addressed by state action rather than at the instance of a private litigant. Because, of course, insofar as an action to set aside for fraud is concerned, it will only be brought if the losing party decides to issue the claim. And as we have set out in our written case, the criminal law provides an avenue for redress, both in terms of the substantive charges and a conviction, but also in the form of confiscation orders under the Proceeds of Crime Act and compensation orders under the Power of Criminal Court Sentencing Act. Now, we acknowledge that isn't a perfect solution, but we say it is a material factor to bear in mind when the court is considering the policy balance. And it addresses the concern that Mr. Justice Newey raised in his judgment that you may have a case in which someone is prosecuted and convicted of perjury, but the judgment stands because of the application of the reasonable diligence requirement. Well, that's right, but of course the fraudster's been caught in that situation and he can be caused to disgorge the benefits of his fraud. In fact, in that situation, almost certainly would be. Those then are my submissions as to principle and policy. I turn then to the Commonwealth authorities in this area, and first, Australia. These are the cases of Tubia and Clone, which the court has already seen. We address these authorities in paragraph 78 of our written case. In Clone, which is the High Court of Australia case, the issue was addressed centrally or primarily as a matter of authority rather than principle, and we've seen that the High Court of Australia considered that as a matter of Australian law, there is no reasonable diligence requirement, but they considered that as a matter of English law there was, and they'd simply chosen to adopt a different approach. The reasoning in Tubia, insofar as it rests on English law and policy, is, we say, flawed. The case can be found in the fifth bundle of authorities behind tab 61 at page 2449 of the electronic bundle. The relevant parts of the judgments in which English law and policy are dealt with begin at page 2455 electronic 1493 hard copy. Prior to this point, the relevant dicta in the Owens Bank cases are set out but not analysed. At paragraph 27, the court says, both Lord Justice Parker and Lord Templeman relied on the decision of the House of Lords in Boswell and Coates, but as will be seen, it provides no support for the proposition that proof of due diligence is required in an action to set aside a domestic judgment. Well, we say that Boswell and Coates does, on a true reading, provide support for that, and that seems to be the approach that the High Court of Australia took in Clone. Then lower down in the paragraph, there's a reference to Birch and Birch, and the submission of counsel in that case that the Bill of Review reasonable diligence approach should be adopted in a fresh action. And there, the court says, as will be seen, this submission was not accepted by the Court of Appeal. Well, again, we don't accept that. We say that the submission simply wasn't dealt with by the Court of Appeal. Then at page 2457, electronic 1495 hard copy, Justice Handley addresses both Owens Bank cases and says he considers that the dicta are contrary to principle as well as earlier authority. And he notes, well, such a result would be contrary to long-established and fundamental principles. Contributory negligence is not a defence to an action for fraud, whether the relief claimed is rescission or damages, and then refers to the dictum of Justice Brennan, a knave does not escape liability because he is dealing with a fool. Well, as to that, we point out the distinction between the issue of the consequences of a finding of fraud and the circumstances in which the allegation should be permitted to be pursued. And there are the examples that we've given where the effect of English law is that it may be that a knave escapes liability because he's dealing with a fool. And that's the balance that English law has struck in other areas. Finally, at page 2458, electronic 1496 hard copy, Justice Handley relies in support of his decision on the cases of Hip Foong Hong and Jonesco. But for the reasons that I've sought to set out, we say that, in fact, on a true reading, those cases do not support an argument that the reasonable diligence requirement does not form part of English law. They simply don't address the point at all. We also point out that some of the arguments of policy and principle that we rely on in this court aren't referenced in Tubia. And some of that is unsurprising because, for instance, there's no equivalent in the various Australian state arbitration acts to Section 73 of the English 1996 Arbitration Act. The next authority, Commonwealth authority that my learned friends rely on is the case of Canada and Granitile. They say that this represents the law of Canada. In fact, it's a first instance decision in Ontario only, and there are other first instance decisions in Ontario which come to the same conclusion. The rationale for the decision in the Canada case is set out in the appellant's written case, beginning at page 49. That's the electronic bundle reference, page 49. First, Justice Lederer noted that a due diligence requirement encouraged dishonesty, and then cites a decision of Justice Southend to that effect. We would respectfully disagree. We say it's difficult to think that a party to original litigation will decide whether or not they're going to be dishonest by reference to whether or not there is a reasonable diligence requirement in the test for setting aside a judgment. The second and third principles relate to protecting the integrity of the legal process and noting that the presentation of fraudulent evidence is a fraud on the court. Well, we say that those policy objectives are better met with state action than by a private law claim to set aside. And finally, they say, well, it's inappropriate to place the burden of detecting fraud on an innocent party. Well, the burden is going to be on the innocent party in any event, because the the fact that a claim to set aside for fraud has been brought necessarily presupposes that at some point in time, the, in this case, innocent party must have discovered the fraud. Otherwise, there'll never be a claim. Finally, insofar as Commonwealth authorities are concerned, we point to the case law in New Zealand. And we say that that shows that in New Zealand, the reasonable diligence requirement does form part of the law. And that's the case of Shannon, which is in the 5th volume of authorities, behind tab 60, at page 237 of the electronic bundle, page 1435 of the hard copy bundle. The analysis begins at paragraph 102 of the report, at page 2428, electronic 1466, hard copy. And the Court of Appeal in New Zealand spends some pages going through both the English authorities and the Australian authorities, and they identify the difference. Reasonable diligence requirements in England, no requirement in Australia. The conclusion the Court of Appeal of New Zealand comes to is at paragraph 124, page 2438, electronic 1476, hard copy. This leaves the question of whether there is a due diligence requirement in New Zealand. In our view, there is. Not to have any kind of due diligence rule could, in our view, encourage the proliferation of actions by providing an incentive for parties dissatisfied with judgments to search for further evidence. It could also discourage thoroughness in pre-trial discovery and preparation, as litigants would be aware that, were they unsuccessful, they could later uncover some other evidence to show that the other party's evidence may have been untrue, and thus essentially allow them to run their case again before another judge. Well, we adopt that reasoning. But it's fair to say that in the next paragraph, the Court of Appeal of New Zealand creates a distinction between their law and the law of in England. They say, we consider that the rule is not immutable. The court should, in our view, have a discretion to allow actions to proceed, even if based on evidence that could have been reasonably discoverable at the time of the original hearing. But the court will see from the final sentence of that paragraph, before exercising its discretion to waive the due diligence requirement, a court should at the very least require a very convincing explanation as to why the new evidence was not available at the first trial. The evidence must also be of very high relevance and materiality. Penultimate sentence there shows that even in the exceptional circumstance where they say there's a discretion, still then the reason for the failure to deploy the evidence at the trial is a material factor, which perhaps raises the question of quite what that means. We would say that that species of discretion is already adequately dealt with by the flexibility of the reasonable diligence test.
It's quite clear that the Court of Appeal in New Zealand considered that the discretion went further than the extent of the discretion available here, because here, if it's properly described as discretion, it's what constitutes reasonable diligence. Whereas in New Zealand, the court contemplated the situation that even if it was shown that there had not been reasonable diligence, there would still be a discretion to be exercised.
Yes, I accept that.
But why do you say that we should reject that approach?
Well, in my submission, the problem is already dealt with by the flexibility of the reasonable diligence requirement. That in my submission, what it seems like the Court of Appeal of New Zealand is getting at here is that there is some gap between a really bad reason for failing to deploy the evidence at trial, where they wouldn't allow the new action to proceed, and a failure to exercise reasonable diligence. There's some middle ground there where someone can have a reason where they didn't exercise reasonable diligence, but it's not so bad that we should exercise our discretion to refuse the action. If that's not what they mean, then it's unclear quite what they do mean when they say it's still necessary to provide a convincing explanation for why the evidence wasn't produced at trial. So we say that when one considers that discretion, the residual discretion, in the context of the paragraph as a whole, there's not actually that much room there for the exercise of the discretion. And we say that, in fact, that gap can already be addressed by being flexible about what one means by reasonable diligence.
You invite us not to follow the approach of the Court of Appeal in New Zealand.
We say that the better approach is to just say there is a reasonable diligence requirement.
Yes?
Those are my submissions as to the Commonwealth authorities. Another argument that the appellants run in their written case is by reference to the test for enforcement of foreign judgments. And they rely on the Abuloff case, which my learned friend has already shown the court. They point out that when the English courts are considering the question of whether to enforce a foreign judgment in this jurisdiction, a party can challenge enforcement on the ground that the judgment was procured by fraud without having to show that they've satisfied the reasonable diligence requirement. We say that the rule in Abuloff is anomalous. It has been the subject of considerable criticism, both judicially and extrajudicially, and some of that criticism is summarised by Lord Templeman in the Owens Bank and Etoile case at page 1520 of the electronic bundle. We say that it would not be appropriate for this court to change English law on the question of the application of the reasonable diligence requirement to claims to set aside for fraud to ensure consistency with a much criticised principle.
The problem about foreign judgments is that in relation to res judicata and a number of other matters, for decades the English courts drew a number of completely arbitrary distinctions between a domestic and a foreign judgment, the tendency of all of which was to slightly devalue the foreign judgment by depriving it of some of the legal consequences like merger that attached to English judgments. Most of these things have been swept away in 1982 by statute, and it's questionable whether in an issue concerning policy any real guidance is still to be obtained from the rather eccentric distinctions that English law has in the past made between these two categories of judgment.
Certainly adopt that analysis. That then leads me to the final part of my oral submissions, in which I seek to point out some of the, what we would say are the negative consequences in the event that the court decides to remove the reasonable diligence requirement in this area. The first negative consequence, we say that there will inevitably be more claims of this sort. Parties will, as the Court of Appeal in New Zealand identified, be encouraged to allege perjury after a trial, which, as I say, is, experience shows, perhaps a tempting allegation for losing litigants to deploy. And as the weight of the authorities show, largely these claims fail. Practical consequence number 2, innocent parties will, we say, partly as a consequence of the first point, be obliged to incur time, stress and costs, including irrecoverable costs, of 2 trials to vindicate their rights, if it isn't possible to strike out a claim like this for abuse of process. Because in that situation, the allegation of fraud will have to be resolved at trial. And as I have said, there's no remedy to the innocent party for this, even if they're awarded indemnity costs. They will suffer detriments for which they are never compensated. And all because the other party to the litigation failed to exercise reasonable diligence. And in that context, in a claim which has gone all the way to trial and failed, the innocent party is entirely blameless, and yet they have had the costs and trouble of 2 trials because of the other party's failure. The third negative consequence is that the removal of the requirement will create what we would say is an unprincipled anomaly between the approach to arbitration awards and judgments. The fourth negative consequence is that this would be inconsistent with the general requirement that even parties alleging fraud must exercise reasonable diligence in and about the way they pursue their allegations. The fifth negative consequence is that the change would give rise to unfair and unprincipled inconsistencies in the law, which we say are highlighted by the 2 hypothetical examples I gave the court earlier. Point number 6, parties would be encouraged to hold points back. A learned friend at the outset of his submissions acknowledged that a deliberate decision not to deploy a point at trial would mean that the subsequent action was an abusive process. But of course, proving a deliberate decision on the part of the claimant is going to be much more difficult, practically speaking, than proving a lack of reasonable diligence. Negative point number 7, we say the finality of judgments will be further eroded. Number 8, it would increase the likelihood of the court having to deal with old allegations. Because, as I said in answer to a question put by my Lady Arden, there's no limitation period for these sorts of claims. They can be brought whenever. At least at the moment, the reasonable diligence requirement serves as an indirect way of limiting the circumstances in which old allegations like this can be brought before the court. And
Gordon's article suggests that the only limitation is late cheese.
Quite so, my lord, and there are all sorts of problems with that, providing a proper bar.
It's an equitable jurisdiction, isn't it?
It is, and there needs to be unconscionability, and there are other issues.
Well, the unconscionability will be found in the fraud, assuming it's proved.
Well, of course, in this context, we would be thinking about unconscionability on the part of
The claimant.
Claimant, I think.
Yes.
And the last point that we raise is that the removal of this requirement would indirectly have the effect of undermining robust case management decisions in the original trial. If I might briefly turn my back, Lord.
Sorry?
If I might briefly turn my back.
Yes?
If I can assist further, those are my submissions.
Thank you very much, Mr. Nixon. Mr. Waddell.
Pleased to know that I'm not seeking to do a time grab. I'm trying to stick to my 20 minutes.
Well, we're pleased to know that, but you wouldn't have been permitted to do it at any event.
I know. I thought I'd get mine in first. My learned friend started this morning by saying that Lord Justice Goff's judgment in Hunter was a general application as to when a judgment can be set aside on the grounds of fraud. Lord Justice Goff wasn't dealing with that issue. He plainly wasn't laying down any test or any rule of general application, and you'd probably be horrified to be told that he was. What he said was perfectly opposite to the facts before him and was consistent with established principle. My learned friend then went on to say that Lord Bridges' dictum in Owens and Bracco wasn't obiter, it was part of the ratio. We fundamentally disagree. The ratio of that decision was that Section 9.2d of the Administration of Justice Act incorporated the wide common law rules in relation to foreign judgments. The question of diligence or not wasn't relevant to the matters before the court because the original allegations of dishonesty had been before the court in St Vincent and had been decided. And there was no need to debate the precise scope of the English rule. The proposition was run by the advocate saying that you should import English common law rules. The answer to that was no. And to get the ratio, I would ask you to reread the head note, which you find at E1460, hard copy A430, and then to pick it up at pages 1504 at E, right through to 1506 at F in the electronic bundle, hard copy, that's 622Q, also at E, through to 622S. Now, my learned friend on a number of occasions said we had pointed to no authorities that dealt with the reasonable diligence requirement in this context. But hang on, we looked at Patch, we looked at Phosphate, we looked at Hipfung, we looked at MacDonald, we looked at Hunter, we looked at Arnold, we looked at Toubia and Clone, and all of them, even before we get anywhere near the Ladd and Marshall cases, proceed on the assumption that there is a reasonable diligence requirement when it comes to fresh evidence falling short of fraud. And if they'd thought it applied to fraud, they would have said so. And all of them draw that distinction. So we don't agree with that. This afternoon, my learned friend prayed in aid innocent victims and saying that this court needs to provide protection to innocent victims, that they shouldn't have to be put to the cost of having to face colourable claims. There are a couple of points that arise out of this. First of all, even if there was a reasonable diligence requirement, it would provide no greater protection to colourable claims. If someone's prepared to lie and say to the court, I've now newly discovered fraud, he's bound to go on, he or she is bound to go on to say, well, I couldn't have discovered it beforehand. There will have to be a trial anyway. There has to be a trial in this case, whatever the outcome, because as the Court of Appeal directed at paragraph 55 of their judgments, they've remitted the question of reasonable diligence to be decided at a trial. So querying whether in fact, even my learned friend is right, there would in practice be any savings. If someone wants to come up with a colourable claim, they will do so. My learned friend then put a gloss on this and asked you this question: should my clients or innocent parties wrongly accused of fraud be put to further costs? And he even said put to a further fraud trial. There hasn't been a fraud trial, and in any event, it's a very loaded question. One can quite easily turn it round. I could draw your attention to the fact that the only expert in this case has opined that there is conclusive proof of fraud in this case. There was conclusive proof that a signature has been lifted to forge the relevant document. But the facts of the particular case don't determine the principle. I could ask rhetorically, why should victims of fraud not have their proper opportunity to establish it? The question is, what is the principle here? Where do the authorities to lead you? And is that outcome consistent with well-established principle as to the impact of fraud? And we say plainly yes. And there are protections. Not only does the litigant have to establish the three conditions that I've outlined this morning, newly discovered fraud, it's got to be material, and it's got to be conscious, deliberate fraud. And there are protections. If a litigant discovers this, one can expect him to pursue his or her claim with expedition. Why would anyone sit on it after the event having lost a trial? If someone, for some reason, decides to put that discovery in his back pocket and brings a claim 10 years later, well, then leeches can protect the other side. But it is unreal, and a lot of the arguments this afternoon, if I may say so, are unrealistic. For instance, it was said that your decision saying no reasonable diligence requirement would encourage perjury claims. But the reality is, in litigation, one party accuses the other of lying. If they lose on that and they subsequently discover perjury, it's most likely to be in the territory of new evidence rather than newly discovered fraud. We are talking here about a very rare case where, after a trial, a handwriting expert has been instructed and he's come up with conclusive evidence, conclusive proof, which is a rare thing for a handwriting expert to opine about. My learned friend then seeks to derive some comfort by drawing analogies with arbitration, limitation and such matters.
But just before that, Mr. Waddell, do you say laches applies because the original bill to set aside a judgment had to be brought in Chancery?
Yes. My learned friend draws a comparison, an analogy with arbitration. We say that argument gets them absolutely nowhere. Comparison with an express statutory regime is unhelpful, and it ignores how the common law develops. The development of the common law is an incremental process carried out by reference to decided authority. On that basis, the court asks itself how far the law has gone by reference to decided cases. Having done so, it asks itself whether or not a further development is justified. What it doesn't do is seek to develop the common law by reference to some perception of what Parliament might or might do on it with regard to a particular matter.
Well, in devising, in identifying legal policy, it's very well established that the policy assumptions behind legislation in cognate areas is a relevant factor.
Yeah.
And that, I think, is the use that's being made of, for example, the Arbitration Act point, with perhaps the added spice that an arbitration award may be said to have the same practical status as a judgment.
I think you put your finger on it, if I may say so, when you said in relevant areas, because the policy towards arbitrations is radically different from the policy towards court proceedings. Arbitration is a private process. One of the key policies underpinning the 1996 Arbitration Act was the perception internationally that English courts were too interventionist and were thereby interfering with the dispute resolution process agreed upon by the parties. So there was a conscious and deliberate policy to restrict the ability of the court to intervene. Putting it another way, the aim of the policy was to ensure that arbitration was distinguishable from litigation and not a mirror of it. So we say the fact there's a change in the arbitration law can't help this court decide what the common law is or what the common law ought to be in respect of judgments obtained by fraud, when this court has an interest in ensuring that the courts have a concern to protect the integrity of their own processes.
Can you remind me, was there any report preceding the 1996 Act which set out policy?
My Lord, there was, and just bear with me a moment, there's a report on the arbitration bill by the Departmental Advisory Committee that was published in 1996. I don't have the reference to it, but I would draw your attention to paragraphs 21 and 280 to 282, which talked about the interference of the courts tending to frustrate the party's choice as to using arbitration rather than litigation.
Did the 1996 Act create a right to set aside an award for fraud, or did it exist before? My understanding is that it existed before by virtue of the more general provisions, which date back, I believe, to 1889, in which you can set aside an award for very generally described categories of irregularity, under which fraud would be included.
Yes.
What I don't know is whether there was a common law right to do it even before that. I suspect there was.
I suspect there was, but I can't answer that last point. But so far as the 1950 Arbitration Act, as I recall, and I confess I haven't reread it for the purpose of this afternoon, but there was a much wider power to intervene, and intervention was commonplace in the commercial court. And that's why the 1996 Act was brought in. But if that's the right way of looking at it, one can't derive any comfort or any guidance from what's said in the Arbitration Act as to how to proceed with this issue before this court.
Well, to the contrary, you would say it's positively misleading because it was introduced, if you're right, for a specific purpose which doesn't arise in the present circumstances.
Exactly.
Well, I mean, there were all sorts of restrictions on the court's involvement introduced, but whether this one was...
That reason, well, that's...
I think this one was motivated by that reason, I think, would require further investigation.
I think the position is that the right of the court to intervene on the ground of irregularities under the previous legislation was expressed in such general terms that it was thought desirable to limit the scope to specific grounds which were identified in the Act.
Yes. None of the Commonwealth authorities we've looked at refer to their arbitration acts as giving them any guidance. In fact, the New Zealand case comes up with a different outcome to what its arbitration law says. Justice Handley, when in Tabir and Schwenke, doesn't mention arbitration, nor does the High Court at MacDonald and Clone, and nor does Mr. Justice Handley in his article that I've already referred you to. I would respectfully say it's really not helpful to refer to arbitration. My learned friend then goes on to deal with limitation, and he raises the hypothetical point. Suppose a claimant negligently fails to realise that a piece of key evidence is being concealed from her. She should have discovered it in 2007. Instead, she only finds out in 2014, therefore brings her claim out of time. The second example, claimant B, who brings the claim in 2007, despite negligently failing to spot the same key piece of evidence, and is therefore within the limitation period. Claimant B loses, but then discovers the concealment and successfully applies to set aside the judgment on grounds it was obtained by fraud. Said that that's unfair and irrational. No, it's not. All that happened is a claimant B issued in time and discovered the fraud after the first action.
Might it not be said that the fact that the policy of limitation is not to allow frauds to trump all is an indication, at least, that there is nothing offensive about imposing a reasonable diligence requirement on the claimant who's alleging fraud?
It's aiming at a different target. It's looking at the extent to which or when someone can bring an action, and it has to set boundaries, and those boundaries by their very nature are going to be arbitrary, and they by their very nature risk giving rise to capricious results. But that's not a question that doesn't help you answer the question of how to approach the substantive law and what principles can be derived from existing authorities. I mean, it's to do with protecting courts' own processes. It's to do with ensuring that courts aren't faced with very stale actions, where the quality of the evidence may not be reliable, and so on and so forth. There are a whole host of reasons.
Yes, but in the context that we are dealing with the conflict between allowing a victim of fraud to pursue his or her claim and finality of action. We're trying to protect the court from constant litigation. So it does seem to me that there may be at least an analogy in the case of limitation. But you say it's not a sufficiently close analogy to interfere with where you say the authorities point.
Yes, and it's never been relied on before, and I think the reasonable diligence requirement in the Limitation Act can be taken back to the 19th century so far as real property is concerned. And no one said any time in the 19th century, oh, we better not do this, or fraud unravels all, doesn't apply because Parliament has put this restriction on the extent to which you can rely on an extension to the limitation period. So we say it's not terribly helpful.
Does the Limitation Act speak with one voice on this? I have some recollection that fraudulent breach of trust is accepted from limitation periods.
I think you're right, it is.
By beneficiaries, and I can't remember whether that's subject to a due diligence requirement. But
no, it's not.
My vague recollection is that it's not.
I think you're right. So it doesn't all speak with one voice. My learned friend then rely on amendments. Again, we say there's no comfort to be derived from amendments. I mean, with an amendment, the court is ultimately exercising a discretion. It's a discretion when someone comes to the court very late in the day and says, I want to amend. But there's no hard and fast rule. Just because it's a late amendment, it doesn't mean it's going to be refused. Late amendments alleging fraud in appropriate cases are granted.
Normally be granted if the limitation period had not expired and the effect of refusing leave to amend would simply be to begin a new action.
I mean, if Mrs. Takhar turned up a week before trial seeking to amend to alleged forgery because she had, by that stage, the expert report, it is unrealistic, we would say, that in the exercise of his discretion, Judge Pearl would have refused that application. It may have led to an adjournment. It may have led to a cost sanction, but the fact that the court has a discretion at the amendment stage doesn't inform the principle that you have to decide. And the same goes to case management. Case management goes nowhere. It's said in their written case that a claimant alleging fraud is expected to comply with the court's rules and directions in the same way as any other claimant, and following Mitchell, non-compliance should cause her to lose her claim. But Mitchell's a case about relief from sanctions that attaches to a breach of an order or rule. It presupposes that non-compliance has occurred. That's not what is in issue in this appeal. Rather, this court is being asked to decide whether a rule requiring the exercise of due diligence exists at all. And saying a claimant alleging fraud is expected to comply with the court's rules, yes, of course. But so, with this action, Mrs. Takhar, having issued her fresh action, has to comply with rules. And if she doesn't, she may find that she's subject to sanctions. She may find she doesn't get relief from sanctions. That doesn't help you, if I may say so, decide what the principle should be. And all these case management powers are discretionary, but the reasonable diligence requirement is not discretionary. If it applies, it will shut out someone with a claim. If Mrs. Takhar is right and her expert is right, she's got conclusive proof that the judgment obtained against her was obtained by a deliberate and conscious fraud as a result of forgery. Criminal penalties against nowhere. It's unreal to think that you're going to get the state interested in prosecuting someone who's been acquitted of any misconduct at the trial, or where he or she has judgment in her favour. I don't know when I started.
I think 2 minutes ago.
Yes.
Have I still got
3:22.
Have I got a minute?
Of course you have.
Thank you.
As long as it's a very modest time
It'll
grab.
be very modest. I would encourage you to read at least Meek and Fleming and the Brodie case in our Ladd and Marshall, because they address the reasonable diligence requirement and they make it absolutely plain that so far as they're concerned that it should not apply to cases of fraud. In fact, I would like just to take you to Brodie and then I'll sit down if I may.
Meek and Fleming, Brodie and...
Brodie and Linton, Hamilton and Brodie Britain Racing, we find that E1093, A13259, and we pick it up at 1095.
Sorry, which
I'd follow A13, A13, page 259, and that's E1095. And towards fourth paragraph, when the judgment of Mrs. Lady Justice Butler Sloss, about the fourth paragraph, she says, constantly he found that it didn't comply with the first condition of Ladd and Marshall. Then we can miss out the next paragraph, I think. She says, fraud or deceit, which is proved goes to the root of the litigation, may vitiate the decision of the court if the allegations are relevant and comply with conditions 2 and 3 of Ladd and Marshall, and a prima facie case is disclosed, unless the applicant has not acted in good faith, such as by deliberately not raising the issue at court with knowledge of the fraud. A court would look very carefully at the possibility of a miscarriage of justice if he was shut out from a rehearing of his case. There are two decisions which have some bearing upon this issue. Scone and Scone, their Lordship's House approved the 3 conditions of Ladd and Marshall, and Lord Hodgson at page 817 of the latter report said that where there was a strong prima facie case of willful deception, that was a matter where a new trial would be ordered. That is strictly outside, as was clear on the facts of Scone and Scone, the very strict adherence to the first condition of Ladd and Marshall. In Linton and Ministry of Defence, Lord Scarman set out the Ladd and Marshall conditions and said, I would add that these conditions are not exclusive of other possible special grounds. Deception or impropriety at trial may well constitute a special ground for missing fresh evidence. He came back to that point at page 10, which he said in that case the condition of reasonable diligence had not been met, and he went on, had the other party deceived the court at trial, or had his counsel been guilty of impropriety, I can conceive that the discretion could have been exercised in favour of reducing the fresh evidence. Deception or impropriety by an opposing party could be a special ground. In this case, there was neither. And she goes over the page. Nonetheless, in my judgment, the speeches, this is the second paragraph, both the Lord Hodgson and Lord Scarman support my view that in case of deception or impropriety or fraud, condition 1 is to be considered with a greater degree of flexibility than cases in which such serious allegations are not raised. And too strict an adherence to these important guidelines and Ladd and Marshall should not inhibit a consideration by the court of the justice of the case. And Lord Justice Thorpe makes similar observations in his short judgment. My Lords, before I sit down, 2 things, if I may. Fundamentally, what the other side's case amounts to, that a fraudster who deliberately sets out to subvert the due process is able to turn round after the event when he's been caught out. I set out to deceive you, but I wasn't actually very good, and you should have spotted what I'd done earlier, and because of that, you're not allowed to set aside the judgment. That would be an exception to the rule that fraud vitiates all. And it's an exception that should not be permitted to remain. Finally, I'm told I ought to mention the question of costs. On the face of it, one would have thought costs here would follow the event. So that
I think we'll deal with costs when we
Thank
give our
you.
judgment. Thank you very much indeed. Well, we're very grateful to counsel who have addressed us, those who have participated in the preparation of the cases. We'll go away now and consider what is to be done. Parties will be informed in the usual way when we've reached our conclusion. The court is now adjourned.